5 seconds to go. Start. Thus, after taking into account the overall evidence on record and after appreciating all the surrounding factors, the trial court concluded that the prosecution had been able to establish the guilt of appellant for commission of offence in question beyond any doubt. Stop. The relevant observations and findings of the trial court read as under: para. Now, we come to the most material part of the evidence. Stop. Here, the IO had stated, in no uncertain terms that when he visited the place of occurrence, he did not find the accused thereon. Stop. From the evidence of other witness, it somehow comes to light that the victim was shifted to hospital in the morning hour. Stop. Now, the question is, who had shifted her? Stop. All the witnesses deposed in different directions, but the justice cannot be left to be defeated, even if all attempts are made by the witnesses to derail the course of justice. Stop. Now, reverting back to the evidence of PW7, it comes to light that he made inquiries as regards disappearance of this accused from his house, but none could furnish any satisfactory information as to why he was missing from his house. Stop. Subsequently, the IO came to know that the accused was roaming at Nidanpur. Stop. He immediately left for that place, and on reaching there, he found the accused roaming aimlessly at that place, and he, immediately, brought the accused under his custody. Stop. In the instant case, none had seen the actual occurrence. Stop. From the medical evidence, it stands amply established that the deceased wife of the accused suffered homicidal death. Stop. Her neck was throttled and she was done to death. Stop. Para. From Exhibit 2, the inquest report, it appears that the IO has noted that there appeared spot around the neck of the deceased and the body was stiff. Stop. The doctor, while performing post-mortem examination, has found that there was rigor mortis present there on the whole body. Stop. There was also bleeding from both ears. Stop. He also noted protruded tongue. Stop. Multiple petechial hemorrhage were seen in eyes and face. Stop. Some bruising and ecchymosis were also found on both sides of the neck. Stop. The fact that the death was caused by act of throttling stands eminently established in the instant case. Stop. The accused, during the whole trial, kept his mouth shut. Stop. There are cogent and convincing evidence on record to hold that both the accused person and the victim were residing in the same house together. Stop. Death occurred to the wife of the victim. Stop. The parents and other members of the house were all present there. Stop. None deemed it fit to inform the accused as regards her falling seriously ill, if ever there was any tinge truth in it. Stop. Even the accused did not elaborate on the matter as to who took the victim to hospital after ever she had fallen ill. Stop. The whole matter has been suggested in his examination under section 313 CRPC that he had gone to the other place to procure medicines for himself. Stop. Neither his nature of illness was shown, nor he was found carrying any medicine. Stop.